folks are back. This is Steve Sanson and Jim Jones for Veterans in Politics. We had some technical difficulty on one of our Facebook accounts, so we had to move over to this Facebook account. So just want to let everybody know. Today's guest is Timothy Treffinger. He is a candidate for Clark County District Attorney. And some of you folks will say, really? I thought the race was over. Didn't Steve Wilson won over Ozzie Fumo? Yes, that's exactly what happened. But Steve Wilson has never ran in the general election as a Clark County District Attorney. So this is the first time a Republican of any kind, made a stand and decided to run for this office and give it a more of a conservative voice. Last time Wilson ran for his position of district attorney, he ran against Robert Langford in the primary race. And this time, again, he ran in the primary race, but this time against Ozzie Fumo. But no, D.A. Wilson has not won his election yet. It goes till November. And our guest, Timothy Treffinger, is the one that's going to face off with him this November. With that said, Jim, do you have anything?
I want everybody to, I'll make it real brief because this could be a long conversation. I just want to address a couple things that a lot of people have been bringing to my attention. Everybody out there that is absolutely freaked out about the Supreme Court reversing Roe v. Wade, please take a deep breath and calm down. All they did was send it back to the states where it should have been to begin with. It's a state's issue. It's not a federal issue. So they just corrected the mistake that was made in 1972. So now, more than ever, whether you're for abortion or against abortion, now maybe you'll start paying attention to your state legislatures, which you should have been paying attention to all along to begin with, because they are the ones that are going to have control over that issue going forward. So everybody relax and actually take your voting seriously and start voting for the proper legislators, whichever side of the aisle you're on or whatever your opinion is on that issue. I don't give my personal opinion on that issue. And I'm very excited to have Tim on. One thing you did leave out, we endorsed him.
Oh.
We endorsed him. Now, one thing about our endorsement process that some people may not understand is we do it pre-primary and we invite every candidate. So it doesn't matter if you're a Republican or Democrat, you all come in at once for whatever office you're running. You answer questions that are given by a panel, okay? And it's not just a sheet of paper that your campaign manager fills out and mails back in, okay? You have to actually come in, answer real questions. Tim was on with Steve Wilson, and we endorsed Timothy because veterans in politics, I know personally I strongly support this individual for DA, and he did earn our endorsement.
And thank you for that. I appreciate it.
Oh, absolutely.
With that said, without further ado, Timothy Treffinger, please tell us about yourself.
My name's Tim Treffinger. I have the honor of being the Republican nominee for the 2022 Clark County District Attorney's race. I've been a longtime resident of Nevada for the last 10 years. Came here after law school, started with the Story County District Attorney's Office up in northern Nevada, came down and worked for the Nevada Attorney General's Office, prosecuting sex crimes, crimes against women and children, and then went into private practice for about the last 5 years. And as Steve referenced earlier, I'm proud to be the conservative voice in this fight. I think that the DA's race is an important one at the county level. It has massive implications for crime, safety, family court, other things in the community. And I'm happy to bring some conservative values back to this race.
Okay. What we're going to talk about today, because you came on the program not too long ago, right?
Yes.
Okay. We wanted to really hit the family court issues because there are a lot of litigants out there that really want to know where Clark County District Attorney stands on these family court issues. And Jim is going to go ahead and start it off, and then we'll go from there.
Okay, so one of the things First, I just want to let Jennifer Bandero tell her I hope she's feeling better. We had her on a while back. We've had a bunch of litigants that have been dealing with family court for a long time, and they're not doing a very good job, in our opinion. And it's frustrating because the children are the ones that suffer. So our education is lacking here in Nevada, and now our family court's a mess too. So the children are really suffering in the state of Nevada. With that being said, my my first question is, Steve and I have been talking about this for a while. What's your feeling on having jury trials in family court, specifically when it comes to relocation and then also removal of parental rights?
I would be for jury trials in those instances. I think that the constitutional right to a jury trial is something that needs to be protected. I think that's something that's severely lacking in our family court. You have judges doing bench trials on very serious issues where they're supposed to take the totality of the circumstances into account, but it's one person's opinion. And you go into different family court departments, you have different one person ruling on these cases. Every department rules differently on various issues, and you really don't know the outcome. That's not how the law is supposed to work. You should be able to have a predictable outcome. And if you have a sample of the community, which a jury gives you, I think that gives you more reliable outcomes than just simply doing bench trials.
Okay, well, we've asked other judges and other people about this, and their pushback to us always is, well, some of the issues that get brought up in these cases are just, they're really heinous, and they're worried about that getting out. Like if there are jury trials, like somebody on the jury would leak that to somebody in the community, or is that would that be a concern of yours with jury trials? Or
I can't say that it would be. I used to prosecute sex crimes, the most heinous crimes we have. We use public juries for that. We use public hearings for that. You can have a gag order on a jury. I mean, there are ways to protect against that. I think that's kind of passing the buck a little bit. You can't be concerned of things that happen in criminal cases happening in family court. It's just not happening out there.
Okay. And then just one last other thing too. People are talking about, and for me it's a cop-out, but I want to know what your answer is on this. It's hard enough to get people to report to jury duty, so they're worried about not a large enough pool. That's another thing that gets thrown out a lot.
That's an amusing cop-out, I think, because we're able to pull juries on civil cases. We're able to pull juries on criminal cases. I don't think that just because it's family court, people aren't going to show up. Hell, half the time you don't know what kind of case you're on until halfway through jury selection. Okay. So no, I don't agree with that. I think the jury pool is the jury pool. We have a great jury pool in Clark County.
Okay. And then another issue that comes up.
I wanted to just
Go ahead,
to just piggyback on that one.
Yeah.
If the Seventh Amendment is in our Constitution, the right for a jury trial, and the 14th Amendment is in our Constitution, the right for a fair judiciary, then why isn't there any jury boxes in family courtrooms? There are no jury boxes in no family courtrooms in Clark County. There is absolutely no jury box. Was it an intention all along to violate people's constitutional rights, because they build the courtroom exactly to violate their constitutional rights?
And that is something that should give people pause, I think. There's lots of courtrooms, even justice courts, that should have jury trials for certain types of cases that don't have jury boxes either. It's certainly something that makes you question the choices that were made back when that courthouse was built and the perspective on people's rights back then. And I think it signifies that they never planned on having jury trials.
Isn't that alarming, though?
It's extremely alarming. But all we can do now is reform it and try to fix it. I mean, this has been a problem that's been going on for years. I know for as long as you've been doing this program, this has been a major issue. And there's all these cop-outs, the jury pool. People don't want to show up. People aren't interested. People say that the outcomes are going to be strange, but we trust juries for serious criminal cases where people potentially lose their lives in this state. We have the death penalty, but we don't trust juries for family court cases. It makes no sense.
But as a DA, what could you do about that?
I mean, if there's a corruption issue, it's certainly something that can and should be investigated. I don't know why everyone seems to be so afraid of the judiciary, specifically in family court. It shouldn't be that way. We're different arms of a system that's supposed to work together. But my position is if there's corruption or something going on that shouldn't be going on, it's going to be investigated and prosecuted by my office.
Yeah.
Yeah, and thank you for that, because I think that one of the things that frustrates me about people, elected officials, is they always say if it doesn't specifically relate to them, then they're just going to not discuss it at all. And I think that like elected officials, even if you're not necessarily in a position to do something about it, you do have a bully pulpit. You are a part of the community because people voted you into office. So you should give your opinion when you see things that aren't right. You should stand up and say things.
Of course. You are an elected official. You do represent the community. And I mean, the DA's office lobbies for things with the legislature. We all know that. You do have a pulpit to try to change things. Now, they usually specifically focus on changing criminal procedure, criminal laws, things like that. But if there's corruption going on in your community, I think you have the duty to investigate that, whether that's family law, whether that's election integrity, whatever that means. You have a mandate to investigate and prosecute crimes without passion or prejudice. If something's being done wrong, it should be fixed.
And then another issue that is frustrating with family court is pro se litigants. So there's the old adage that I forget the exact wording of it, but like if you defend yourself, you have a dummy for a client or something. Fool for a client or something like that. But there are lots of times pro se litigants in family court are specifically these are the two main reasons that come up that when I discuss this issue with people. Either one, it was hard for them to find an attorney to take their case because a lot of attorneys aren't taking family court cases just because they don't understand the rules in family court, because every judge kind of just does their own thing. So that's part of it. And then the other part of it too is that unfortunately, it seems like a lot of these judges in family court are, when it comes to like relocation or removal of parental rights, they tend to be going after the good parent, knowing that will make the good parent more emotional. And then when they do run out of money and they do have to become pro se litigants, which means that they're acting as their own attorney, then when they start filing stuff with the court, they're automatically deemed vexatious. But attorneys are filing briefs and motions constantly. And I've not once, I could be wrong, but I have not once seen an attorney be called vexatious in family court.
No, I've never seen it. And you're right. I mean, there are some very aggressive attorneys out there that will file anything based on anything their client says, which is not what the rules say you're supposed to do. Right. You're not supposed to file anything that you don't think has a chance of success or there's no merit to. And this is a big issue in family court. I'm one of the few attorneys I know that does flat fees in family court, which is almost unheard of because of how much time and energy it takes to do those cases. Right. But that's the only way I can fairly represent my client because they do run out of money. I mean, you're talking about $200-$300 an hour. These cases drag on 18 months, $50,000, right. $60,000, $70,000. Not many people can afford that. And then, they lose their attorney. They start filing stuff because they don't know the rules. They get labeled vexatious. And then that follows you down the line for any other lawsuit or any other legal issue you file. And you have to go through these extra steps to get into court. And it really denies you access to the court system.
Could you explain what vexatious means so that people would understand?
Sure. So vexatious litigants are litigants who have a history of filing things that the court deems are inappropriate or improper or lack merit. So basically they're saying you're just wasting the court and the other side's time. I shouldn't say plaintiff because either side can be a vexatious litigant. But basically once you have that label, once a court determines you as a vexatious litigant, anything you try to file has to be reviewed. There's bonds that can be put in place. There's all kinds of negative connotation that goes along.
Isn't that a constitutional violation to stifle a litigant's right to defend themselves, which is against the 14th Amendment?
I would argue that it is. It's a relatively new concept in law. I mean, it doesn't go back to the origins of common law or anything like that. Mm-hmm. But at the same time, courts are trying to do things efficiently, and sometimes they sacrifice rights for efficiency, which is something that should never happen in this country, but it happens all the time.
Okay.
Sure. Okay. And then what could you do to address? We had Jennifer in here, and she was discussing what she could, Bendero, about her case, and what happened was Judge Steele came in. Mm-hmm. And because I think she had another judge before.
Ochoa, I believe.
Yeah, she had three. I think it was Ochoa first, and then it was, I always forget her name now, Judge Moss.
It was
Moss, and then it went to Diane Steele. The reason why I bring up Judge Steele is because she ran for CD1. And I asked her when we were doing the endorsement interview about some of the bad behavior that was taking place, or not, her peers and family court not following the rule of law, and how she could just see that occurring and not do anything to address it. And she said, well, I always just look for the Judicial Disciplinary Commission, to deal with it. Well, what could you do as a DA to revamp that? Because it's like a joke. A lot of these judges are like, yeah, okay, they're going to file this big deal. And they don't even take a lot of this stuff seriously.
That's true. And I think a lot of attorneys hesitate to file judicial ethics complaints because now you need to, peremptory challenge the judge and get into a different department and do all this other stuff because you're worried about some kind of reprisal.
Right.
I've seen a lot of crazy things in family court. I was once, because I gestured in the direction of opposing counsel who was in front of a judge 3 or 4 times a week, and it was my first time in her courtroom, accused me of intimidation and harassment of her, which was funny since I used to prosecute violence against women act crimes, but literally dressed me down in front of my client for 10 minutes.
Wow.
Over that.
Isn't that a violation of the canons, though?
It is. Well, where's the civility? All the signs that say we want civility between the attorneys, we need civility from the judges in some circumstances too. Yeah. That judge is no longer on the bench. I won't mention a name. Okay. But sometimes those issues resolve themselves. But the DA's office can be sensitive to some of that stuff. If it goes to the point where you're violating people's rights, I think at that point you do have an investigatable offense, potentially. Right. I think keeping an open door policy and taking those complaints and taking them seriously and giving people an outlet to voice those concerns to someone who can do it. And if I can't do something about it, refer them to someone who can. Because it's hard to do things directly, but there's always a solution.
Right, yeah. If nothing else, you're a good resource.
Correct.
And you're willing to be a good resource. That's very important. Steve, did you want to ask remove or retain?
No, you go ahead.
Can you work? Okay. All right. So we've brought this up before. I'll briefly go over what remove or retain is.
Then I'll piggyback if you need to.
If I mess it up or don't clarify it as clearly as possible. So Steve came up with this idea, and it was a really good idea because for years, just give you a little background, for years, Steve and I were always kind of, I wouldn't say battling, but we were having a discussion back and forth on whether judges should be elected or appointed. And we both, it's interesting because we both kind of came into the middle of it. Kind of came to the middle because we're like, okay, we can see where it's bad on the election side, right? But we can also see where it could be really bad on the appointment side too, correct? So now, what Steve proposed, what they call remove or retain. Now, this bill would only apply to incumbents. Okay, and basically what it's saying is, so if you have an incumbent judge and they run unopposed, okay, then as it is right now, they're unopposed, they automatically win. But remove or retain would be, it would have the judge's name and then you would have remove or retain on there. If retain gets more votes, then the judge wins, they stay on the bench. But if remove gets more votes, then it goes, then what ends up happening is they're removed from the bench, obviously. And then attorneys or whoever is qualified then puts in application to the Commission on Judicial Selection. They pick 3, and they send those 3 to the governor, and then the governor appoints someone. And then they would have to run for re-election the next time. And the reason why we wanted to do that, or that Steve proposed this, was because lots of times what happens is you have these lawyers the judges that have been well established and have been on the bench for a long time or whatever, and they kind of get a reputation for being, let's just put it this way, they don't like to be challenged on stuff. So if somebody runs against them and loses, and then now they're going to have to come back in front of that judge, we're worried about that judge retaliating on that attorney. So what is that about right, Steve? So what's your opinion on remove or retain? Do you think that's a good bill? Because it didn't get out of committee, but we're going to send it.
And let me just piggyback on that. Well, judges have judicial immunity, right?
Right. Yeah.
Okay. And judges are they don't have term limits,
right?
So they could be on the bench for how many years? And judges, the Supreme Court in the Catherine Ramsey case came down with the ruling that you cannot recall a judge.
Right.
So, and I didn't understand how the Supreme Court could interfere with the executive branch, because the Supreme Court is a judiciary branch, and every single elected official you could recall. Right. Why is it that judges have this extra blanket of security that you cannot recall them based on a policy from the Supreme Court? That should have went before the voters. That should have went before the assembly and the state senators and the governor to sign into law, not an opinion that's now kind of like law.
Right.
Against judges being recalled. So with that said, how do you remove a bad judge if you got attorneys that won't run against a judge? If there's no and there's no term limits, and you can't recall the judge, and the Judicial Disciplinary Commission, put their nose up in the air about any complaints you file against that judge. So how do you remove a piece of crap off the bench that's been destroying families for years and will continue to destroy families for years to come if that person remain on the bench? What type of power do the people have to get rid of this bad, corrupt judge? Is to remove and retain.
And I agree with you on that. Absolutely. I think that name recognition does not make you a good judge. So you need to have some other method of removing people from the bench when attorneys aren't willing to run against them. Right. I think the fear of reprisal is a big reason you don't see some judges getting challenged. And if that's your bread and butter is family law, then you can't practice in front of a certain department effectively. That's going to hamper your ability to continue your practice. I think remove and retain gives the voice back to the people, because at that point, if there are litigants like the guys and women you deal with have an issue with the judge, they can effectively campaign for remove.
Exactly. Right.
And that's not something that they have right now. Now it's just one name on the ballot, one vote wins. Obviously, someone's voting for that. is going to check that box.
Yeah. They better vote for themselves.
One would. You never know.
Yeah, you never know.
Arrogance is a thing.
It is.
But I think that retain or remove would be a great thing. I don't think any public official should be afraid of being able to be removed if they do a bad job. If you're not serving your constituents, get the hell out of office. And if you won't leave on your own, then there needs to be a method to remove you.
I agree. Thank you for that. Because just to point out to your opponent dodged that question.
That's true.
He said he needs more information. I don't know how much more information he'd need, but thank you for answering, and thank you for answering honestly. Like, you could have said no. That's a terrible idea. I don't know what in the hell you guys were thinking. Hey, at least you would have answered the question. That's the thing that drives me nuts about politicians. Well, I'll look more into that. Yeah, okay, yeah, sure you will, buddy. All right, whatever.
But this issue is strange, because the last time you guys asked me about this, and I gave a similar answer,
right,
3 or 4 attorneys came up to me the week after and said, "Hey, I saw you on Veterans in Politics. You're a brave man." I said, "Why?" They said, because of remove and retain.
You told me that.
I was like, this is not a scary issue when you got the death penalty and parental right termination and everything else. Remove or retain's the scary thing. It makes absolutely no sense. Don't be afraid of the issues. And if you're afraid of the issues, why are you in office?
Exactly.
Right.
Exactly. How are you representing the people effectively?
Right. If you need more time to look into the issue after X amount of years as a city council person and 10 years in the DA's office, that's an awful lot of research.
Yeah. Please continue.
Did you want to ask the rest of the family court questions that Michael did?
Sure. I have a few. Who has jurisdiction to tell a litigant? Who could force? What type of judge could force a litigant to take a drug test that have jurisdiction to tell a litigant to take a drug test, to order a litigant to take a drug test?
That's an interesting question. Are you asking who exerts that jurisdiction? Because all of them do.
But who has the jurisdiction to do that?
In a criminal case, it's that would be more normal in a criminal case.
So, and a family court judge is seen as a civil or a criminal?
Civil.
Civil. So if a criminal judge has the jurisdiction to order a litigant to do a drug test, then why is it that family court judges who are civil is doing the same thing the criminal court judge does?
It's probably being done inappropriately. It's probably a violation of the Sixth Amendment.
It
is. I should say it is.
And I was told many times, as soon as that's done, you file it with the Supreme Court, and they'll overturn the decision. But a lot of family court litigants don't have this knowledge. They don't know. They don't even have the money to do it. They wouldn't even know what the first step to do. Why? And then while they're trying to figure that out, the judge saying, okay, since you're not going to take my drug test, I find your urine dirty. Right. Therefore, I'm going to use the child as a sword, which is against state law, and hold the child hostage for you. So instead of dad or mom being the alienation, parental alienation, the court is going to be the parental alienation from your child because I deem your test dirty, although you're telling me about your constitutional right, but I don't care about that.
Well, that's an interesting thing. And you say, file it with the Supreme Court, but usually they give you like 2 hours to go take that test. And I don't know many attorneys that could get something filed with the Supreme Court that fast, let alone a pro se litigant.
True.
It really puts you behind the eight ball. And don't get me wrong, I think it's improperly done in some criminal cases where someone's got a drug history, someone comes in for a normal hearing, and all of a sudden they're getting drug tested, even if they're not showing signs of being impaired. Mm-hmm. It's an issue of violation of rights, but I think, unfortunately, where we're at now in Clark County, constitutional rights are being violated every day in our system, and that's something that needs to be looked into. The Attorney General's office doesn't seem to be doing that right now. That's why I'm hoping Sigal Chadha makes it in there. And the DA's office it suits the DA's case a lot of times if they test dirty, whether that's in criminal court or because the DA's office does handle most parental right terminations as well. People don't realize that. Mm-hmm. I think it's being done inappropriately, and I think it's a policy that everyone should be objecting to. Both sides, plaintiff and defendant's counsel, should object to something that's a violation of a constitutional right.
Okay. Is there any, like you said, the 2 hour thing? Is there any way that once, I guess the best way to word it is there any recourse? So they can't get it filed within the 2 hours or whatever to the Supreme Court, and they do what Steve said, either just say, okay, you're dirty because you refused, or if you do it and you're dirty, well, that's a different scenario. Right. But what I'm basically saying is there any recourse after that?
It could certainly be built into an appeal. But that's at the end of the case. That's after all this alienation that you described has already occurred. Mm-hmm. Okay. Because you can't, if you're appealing the order, but you've already gone and taken the test, your appeal's moot.
Right, that's true.
So it's forced to be kept in reserve until the end. But again, pro se litigants can barely get through trial. I've just done recently 2 divorce trials with pro se on the other side, and they're a complete disaster. Yeah. And then, they don't know how to appeal. They don't know the rules. They don't know. And trying to find appellate counsel is way harder than trying to find a family court attorney.
Yeah, I bet. Okay.
So, not really a good solution there. Once it's done, it's done.
All right.
So this is going to be a little bit more to the purview of the district attorney's office, because you guys have the support division.
Yes.
Okay. So if elected, what would you do to change the child support enforcement and throw in disenfranchised parents in jail every quarter for non-payment of child support?
I think we are creating a little bit of a debtor's prison issue with the way it's being handled right now. I've appeared in that division before the hearing master. If you're clients set on the later in the afternoon calendar, you can know that the judge is at least considering throwing them in jail. I don't know that we should be asking for jail for these people for a couple of reasons. Don't get me wrong. Parents need to pay child support if it's ordered. It's for the support of the child. That's important. But I have yet to hear a good explanation as to how throwing a parent in jail who's employed helps pay that debt off. Because you're more likely to lose your job and not be able to make the child support payment. And now you got another 90 days hanging over your head.
Right.
The DA doesn't have to ask for that. They don't have to ask for these lengthy jail sentences. And quite frankly, it obviously doesn't work. Some people, will find any way to make the money, and maybe they go out and commit crimes to get that money, and then now you're increasing crime in the community. I think it should be a policy that we don't ask for so much jail time. You can bring them back in. You can sanction them in other ways. Jail should be a last resort, not a first resort. And I think we very quickly go from, oh, you're not paying, to, oh, you're going to go spend 2, 3, 4 weeks in jail sometimes.
That's a long time.
Yeah. And usually they'll do it a week at a time, but I don't want to spend a week in jail. I don't think anyone here wants to spend a week especially not in our jail.
You could knock somebody out and only spend 3 days in jail.
I just saw, you could steal a car and be out in 2 days if they deny charges. So, it's...
I know where you're going on that one. That's good.
Yeah. It's just, and that's the consistency problem. The jail is for criminals and for people who are hurting this community. And don't get me wrong, if you're a deadbeat parent who's not supporting your kid, you are in a way hurting the community, but it's a way different standard.
Right.
So that's my position on it. We don't need to ask for all that jail time.
Okay. So is there anything you can do to stop the enforcement of taking parents' license away for non-payment of child support?
That's a tough one, because there's two different sides to that question. You have the local issue where if it's a Clark County case, you have a little bit more leeway on how the case is handled. If it's an enforcement action from another jurisdiction, all your mandate is to enforce the order from the other court. And I think at that point, we can't just completely discredit judges' orders. That's not our position. But I think at least for the local cases, certainly we can address that. The people who put the block on the license is the DA's office. So, I mean, you need to be more willing to work with people. Same thing. If you can't get to work, how do you pay your child support? If you're in jail, how do you pay your child support? The passport thing's a little different. I don't know you need to be going on massive international trips unless that's part of your work. Right. But for the simple stuff, like being able to drive, and then those are the same people who continue to drive, get tickets. Now they're getting thrown in jail for child support and for their traffic warrants. It's just, it doesn't make sense.
Are you aware of the federal child support enforcement laws, Title 42, Section 666, allowing the states to take away drivers and professional license for non-payment? If elected, would you work with parents on payment programs and stop the harsh incarceration and seizing of people's means to get around and make a living?
Absolutely. I think that's important. This is like kind of anything else. You want to give people a chance to do the right thing. Now, don't get me wrong. If you try to work with somebody and they're not going to do the right thing and they're going to be intentionally underemployed and do that sort of stuff, sure, those people can go to jail after they're given the chance to do the right thing. But we don't jump straight to, well, I'm going to throw you in jail so you lose your job. I'm going to take your car so you lose your job. I'm going to take your professional license so now you can't do what you went to school and are probably paying off. I know I'm still paying off law school debt in order to make money. It's counterintuitive. It sounds great on paper that, oh, these people are definitely going to pay. I don't know that the statistics would bear that out.
What do you say about judges that use their discretion versus law? I mean, it's especially in family court. And the way I look at it, discretion is my personal bias. Right. This is how I feel. These are my life journeys that I've encountered with. So now my perception is this way because of my life experience. That's what a discretion is. It's a personal bias. Why are family court judges allowed to use their personal bias that we describe as a discretion versus law that we send people to the assembly and state senate and governors to sign the law or put on the ballot, and we put all this money in creating a different judiciary separate from the executive branch and all that, to have judges use their personal discretion on the bench when people's lives are before them, because that's what family court is people's lives. And it just doesn't just stop with that one judge's court order. It continues. because some of these court orders carry, and a lot of judges, they don't want to rule against their own colleague judge, so they support that other judges screwed up court order just because they want to stay friendly with them. So why is discretion versus law in family court?
Part of that is because of the statute that our legislature enacted. You got to realize the totality of the circumstances and the way that those statutes read require discretion. And that's part of the reason I'm for jury trials in family court. Mm-hmm. When you have a statute that says, hey, look at all the circumstances and weigh each one. Well, how do we weigh circumstances? You're going to bring your bias. You're going to bring your personal opinions. Yeah. Because that's a real open-ended thing. I mean, I'm trying to think of a good example. Who's more likely to foster a relationship with the other parent? Well, that's a great thing in theory, but how do you weigh that? What are the qualifications there? What's the level of conflict between the parents? Purely based on the judge's opinion and the arguments of counsel. There's all these weird, prongs of these tests, and unfortunately, they're discretionary at the end of the day. That's why having a sample of the community weigh them, where you can have, and I don't care if the jury's back there for a couple days arguing this. I think it's important, especially on a relocation case where you're ripping that kid out.
Yeah, exactly.
Get more than one opinion, or do a panel. I would be more comfortable if they did a panel of judges. Even do something other
like
than
a tribunal.
Right.
Yeah.
Correct.
Explain a contempt of court.
That's another interesting concept we have in our courts. So there's civil contempt and there's criminal contempt.
Now, what's the difference between the two?
Civil contempt is generally just a sanction of some sort that can be put on your case, whether that's money or having a case dismissed or something like that. Mm-hmm. Criminal contempt is a misdemeanor charge where it goes on your criminal record, you're arrested, you're sentenced, and the weird thing is you're found in contempt. Usually they give the person a chance to apologize, whether or not they have counsel, and then they sentence you right there. It's a real quick and dirty process. Mm-hmm. Criminal contempt is like any other misdemeanor. You can be sentenced up to, I think it's 90 days in jail now, which is less than the full term.
Right. But so we talked earlier, and we both agree that a family court judge is a civil judge.
Correct.
So why are they allowed to lock people up?
Their position would be that the direct contempt.
Shouldn't they trail that to a justice of the peace?
Sure.
And let them handle it because that's criminal. And they stay in their own purview of civil?
That would be preferable. And some of the things that people are held in contempt for could be a prosecutable offense by the DA's office. There's usually a deputy DA in court for some of this stuff. Refer it to the DA's office. Let the DA's office handle it. At least it's cleaner and we're protecting people's rights that way. I don't know of any reason why someone needs to be put into custody right then. Mm-hmm. It doesn't make sense. But there's a lot of stuff in family court that doesn't make sense.
And when a family court judge ruled that they're going to do a contempt of court proceeding, mm-hmm. don't they already have a predetermined bias in their head that this person is guilty?
One would assume so.
So shouldn't the 14th Amendment apply to them because apparently that litigant is not getting a fair judiciary at that particular point?
Well, right. Contempt of court is one of the few things where the victim, the court who is the victim of a contempt, mm-hmm. is the one ruling on whether or not you're guilty and then what your sentence is.
The victim rules on whether they're victimized or not, basically.
Right. Which is the only part of the system that happens in, because I can tell you, just running this race, I've heard from a lot of victims who don't get their voice heard by the DA's office. So, I mean, it's an overrepresentation in a way.
Okay, so my next question would be on that then. Since we've went through quite a few different questions on family court now, and you've given your opinion and stance on them. So what specifically that's going on in the DA's office now that once you're elected will what's your initial steps look like once you get elected to kind of try to, obviously you don't have a magic wand, you can't do it in one day, but sure. do you have kind of a rough idea of what your process would be after you get
Absolutely
elected?
So part of the biggest issue is a leadership problem. And part of the leadership problem is I think the current DA is so far removed from court proceedings because he hasn't walked into court and prosecuted a case while he's been there, that I don't necessarily know that he knows what his frontline deputies are doing. And I think getting into court and assisting those deputies starting day one, and obviously your schedule doesn't allow you to have a full caseload,
right.
but at least going into courts, I mean, you see, you've seen the elected DA walking around the courthouse drinking a coffee in the morning. He could be in court observing his deputies during that time. That's the first thing I would change. There needs to be a little bit more monitoring that the policies are being followed consistently. Based on some of my recent experiences, I want to start interfacing with some of the victims of crimes, both whether they're tourists who feed our industry or locals. I was contacted by a gentleman this week who had his car stolen. They basically denied charges, even though the DA's office denied charges, even though they stopped the gentleman in the car, which at least a possession of stolen property charge, but it was, hey, I didn't know it was stolen. I borrowed it from my drug dealer. And they just let him off with that, and then made the citizen bail his own car at an impound. And there was evidence in that car that now can't be used in a future prosecution if more evidence comes down. That is a complete failing at every level. Metro screwed that up. The DA's office screwed that up. And this guy, he got his car back, but he's missing a bunch of other stuff. So that type of stuff can't happen.
I want to talk a little bit about a rule of evidence. And what is a rule of evidence in your opinion?
There's quite a few of them. I mean, there's all kinds of rules of evidence that we have to do the ritual of getting stuff into evidence foundation and providing the correct copies and doing all that sort of stuff. So are you asking about a specific one?
Yeah, because I want to move to family court because the rule of evidence doesn't apply in family court.
The civil rules of procedure apply, but they're used very loosely.
They are none at all, because I've sat there and I've heard one litigant say how the other litigant is a raging alcoholic and didn't have one piece of lick of evidence to support that allegation, but it was all theater. Mm-hmm. A little crying, a little tear, a little joke back and forth. You do the whole. It's like what's the Hollywood Walk of Fame?
Oh, yeah.
That's exactly what family court is. Sometimes it's theater, mm-hmm. and one person is more convincing over the other.
Sure.
And then the judge orders on dad's vehicle mm-hmm. without any evidence, no affidavit, no evidentiary proceedings, no nothing.
Right.
Why are they allowed to do that?
That's an interesting issue, and there's a couple different levels of failure there. And I don't know if this was a pro se case, because pro se litigants are given a wide berth as to what they can and can't say, whereas attorneys are kind of held to the standard.
It was a pro se case.
Okay. So yeah, if no one objects to what's going on, the judge technically is not supposed to insert themselves, although they often do, mm-hmm. and lodge their own objections or ask their own questions, which is always a little strange.
Right.
But at the end of the day, you're right. A lot of court is theater. If you go back and look at the O.J. Simpson case, you go back and look at other major cases, the Amber Heard case recently, mm-hmm. It's all theater. Mm-hmm. At the end of the day, we're producing the best production we can with the evidence we have to try to sway an opinion. But there should be a little bit of tighter control, especially on cases where it's pro se on either side, because a lot of stuff comes in that never should come in. That's the great thing about having an attorney, if you can afford one or find one to take your case. But they probably should be striking a lot of that stuff from the record. The mm-hmm. courts have a duty not to take evidence into consideration that is brought up inappropriately, and I don't think that's being done, and that is something that needs to change as well.
So the courts hire these third-party entities, or tell you to hire these third-party entities, whether it's a psychologist, sure. or whatever the case might be. And then they tell you to go through some names, mm-hmm. right? And then you got to pick these names, and both parties supposed to agree, right?
Right.
And then when you pick one of the persons that you're going to use as your therapist, to get this custody thing moving along, they charge you like $10,000, $15,000, $20,000.
It can be.
And if you have a pro se litigant who's representing oneself, how are they going to afford half of that?
They can't.
They can't.
Right.
And then the case keeps moving and moving and moving and moving, because this particular order is not completed.
Right.
Why can't a litigant? It's really a two-part question. Why can't a litigant use their medical insurance to find a therapist and use their co-payment to pay for that, instead of coming out of pocket thousands and thousands and thousands of dollars? And why does a judge become a collection judge and tells the litigant, if you don't pay for this therapist, you're not going to see your child until that payment is complete? Why is that?
I think the first part of your question is squarely aimed at your insurance companies. I worked in insurance law for about 6 months, and I will never, ever do that again because they don't like to cover a lot of things under better circumstances than even this. And a judge's order is not going to make an insurance company pay for that. That's part of the reason. As far as the collection issue, look, if they provide the service, I don't think that necessarily should be part of the family court case. I think it's irrelevant to the family court case. The report should be what the report should be. And, if there's a payment issue, we have civil courts, we have small claims court, we have other courts for that. I think it just puts an undue burden on someone who's already struggling, because you're talking about pro se indigent people. You can make a motion to the court for funds, but are they going to grant that? Do they even know that option exists? Probably not. So I agree with you. I don't think it should be in the family court spectrum. I think that should be moved over to the civil courts. Now, if their therapist won't do the report without the money, then you got to find somebody who's going to be reasonable. There are reasonable therapists out there. We recently did a reunification therapy for $150 an hour, which is nothing.
That's cheap.
So I'm keeping that person on reserve for future cases for sure. And she came to court and was fantastic.
Wow.
So there are good people out there who are not price gouging. Unfortunately, some of your really good expert witnesses are just really expensive, but it's a boutique thing. They know they can command $400 an hour, and they're going to get it because people want to win.
Mm-hmm. What about attorneys that knowingly perjured themselves?
The standard answer to that is they should be disbarred. We're not allowed. The rule is you're not supposed to put anything into evidence or elicit any testimony that is false.
How come judges don't move on this? Because there's a lot of judges that catch attorneys in lies and falsehoods, deliberate falsehoods, and don't file against them. Don't file a state bar complaint against them. And my whole theory of the state bar, I don't think they're doing their job as far as moving out corruption out of that type of industry, which is the industry of law. Right. They're just not moving out the bad critters that are in there.
Right. And you just got to the basis of why there's so many lawyer jokes out there is people don't trust us. That's what it comes down to, because we don't get rid of the people who are doing bad things. Mm-hmm. I can think of several opposing counsel who I hate going up against, because that they're just going to say anything that they think they need to say to win, which is not how the system is supposed to work. Especially in family court, it's really about the kids. What's in the best interest of the child? If your client's not in the best interest of the child, you're in trouble there, especially if you're putting forth their narrative that isn't true.
That used to be the policy back when family court first started. I believe it first started back in 93, 94, if my memory served me right. And the mission was the best interest of the child. Right. That was the mission. That was the whole purpose of forming that specialty court. Mm-hmm. And now it's become not. It's become a policy of financial gain. Because a lot of these attorneys out there are financially raping clients in family court, specifically in family court. And a lot of these judges allow them to do it. Right. And you got pro se litigants that are representing themselves get ordered to pay opposing counsel's attorney's fees. Right. Which they can't even, and they become so destitute and mentally just drained. How, as a DA, what could you do to kind of lift that industry? That is, it's sickening the way they treat families, and I'm saying this because I've actually seen it lots of times. I'm not a lawyer, but I've been down there enough times to recognize what's going on, and it's just pure sickening, and it's like the behavior become normalized because nobody does anything about it.
Right, and that's the problem. And I think part of it is it's not only normalized, but a lot of people, unless you deal with that system directly, you don't realize that type of stuff is going on. Right. I don't know that there's much directly from the DA's mandate that can be done there. Again, unless there's corruption type stuff going on, which It seems there very well may be, and it's something that should be investigated. But it's something that Jim said earlier. You can use that position as a pulpit to shed light that some of the stuff is going on. The DA should be very involved in the community and trying to better the system, even if it's not necessarily directly part of his mandate, as long as he's not neglecting things that are part of his mandate. So that, and I agree with you. I think that many times one parent gives up just because they don't see a financial way out. Or you can pay your child support, or you can pay your court fees, but then you can't afford an apartment for your kid to sleep in, where they have their own bedroom and they're sleeping on the floor or on the couch, and then that gets held against them too. It's a vicious cycle, but it's one that needs to be kind of more exposed to the public, because the public needs to get people in the legislature who's going to change these things.
State law says a custody case, and just correct me if I'm wrong, but state law says a custody case from start to finish is 6 months.
That would be fantastic.
Why are these cases taking decades?
I can tell you that even on a good court schedule where no one asks for continuance, you serve your complaint, 21 days. There's a month gone right there. Answers filed, another 2 weeks for the reply. So now you're 2.5 months in. Usually you don't get a case management conference for 30 to 45 days. Now you're 3, 4, or 5 months in. Discovery is another 2 to 3 months minimum. You're all the way, you've blown past 6 months already. And how many cases go to trial the first time? I would say probably 1%. And the other issue is the custody case never really finishes. I have a divorce case that started 4 years ago, and the divorce was finalized and they settled. But there have been custody motions constantly for the past 3 years, and it just drags on and on and on, and they bring themselves back to court. And
do you think the powers that be made it so that this will happen to grow government? Because family court started at 20. There were 20 family court judges. Well, that's not where they started at. I mean, I think they started at actually 3, and then it grew to 20. Right. But 20 was the good number. And now in this last legislation, they wanted like 8 or 10 more for family court judges, but they were awarded 6. Right. So now there's 6 more family court judges. So there's 20. You see how government just grew? And some of these cases that are in family court, or I would say more than half was over 5 years old.
Right. And they are trying to crack down on that. There is a new Supreme Court.
That is craziness. Yeah. For you to take 5 years of your life in the court. Nobody wants to go to court unless you're a judge, marshal, JA, janitor, anywhere that's going to pick up a paycheck. You go, right? But nobody else wants to go there. So you got to take off work, and it's not like after work, come on down. Right. You got to take work off. You got to go down there. If you got the kids this week, you got to put the kids in the daycare. Yep. The babysitter don't show up, whatever, and you got to get yourself down to the courthouse.
Well, and the strange thing about that too is there's a lot of hearings where the attorneys could really handle it if there's attorneys on the case, but they still require the litigants to be there. Like if the 2 attorneys are going to say, hey, we need 60 days for discovery, let's set a trial date, and the client says nothing, and now I got the client looking at me like, you had me come down to your office for 2 hours for this?
Mm-hmm. When you basically either could have called your client or you had your office send a letter.
Right.
Letter that said, okay, so this is what's going to happen. Unless you have an issue, your appearance is not required.
Exactly.
I will. And then you usually get a letter from your attorney saying, hey, on such and such date at this time, I appeared on your behalf, yada, yada, yada. Yeah.
So sorry. Sorry. You said your office is going to go after corruption.
Absolutely.
Okay. Doesn't matter.
Doesn't matter what it is.
Okay. So if a judge tells a litigant your constitutional right doesn't exist in this courtroom, would that be a corrupt behavior?
Constitutional stuff you got to be careful of because there's a lot of federal jurisdiction there. My answer to that question was any legitimate complaint that's filed with my office is going to be investigated, and if there's a crime I can file, I'm not just going to not file it because it's a judge, police officer, attorney, or anything else. I think that's the consistency that we need in Clark County.
What about if a judge says something that would be considered racist, like have your daughter, next time you bring your daughter in this courtroom, make sure that her nappy hair is combed?
Ooh,
I'm only telling you stuff that I actually experienced. It's not like I'm not making anything up.
No, I know, and I'm pretty sure.
Like in my head right now going, I remember that interview.
And then make that person a senior judge to boot.
I think that shows probably a lack of good decision making in making that person a higher level judge or a senior judge who comes back and sits in on cases. Again, if it fits a criminal statute, I'm not sure that the statement alone would fit a criminal statute. I think there would probably need to be some more conduct there, but that certainly could be a course of conduct for criminal harassment or other things, depending on what else is going on in that case. There's no harm in investigating and filing charges if you think you have a legitimate case, because it's not up to you whether or not that person is convicted. All we do is get the case into court so that a jury can hear it. We're not supposed to care about win and loss records. We're not supposed to, you really shouldn't even be tracking those stats unless there's a severe degradation in the quality of your litigation. Right. It doesn't matter. Get the case into court, let the people, the juries decide. That's what they're there for. You know,
there is a law in California. If you've given $1,500, if an attorney or attorney's firm have given $1,500 or more to a judge, that judge has an obligation to tell both parties that she has or he has received monies from that specific law firm or attorney, and then it's up to the parties to decide to recuse the judge or not.
Right.
In this town, that's not the case.
Right.
Judges don't even say, hey, I got $10,000 from Charles Schwab and Associate. I'm just making that up, but they'll still move forward on the case. There was a judge, right, that had an attorney represent a family member of his, still allowing that attorney to appear before him on other matters without recusing that attorney at all. And that attorney's working, is the attorney representing a family member of his.
And that's...
Is that corruption?
It depends. Now that depends. Are the rulings that are coming out of the cases that attorney is in still fair and impartial?
Oh, no, it's not.
Then yes, because that's clearly a pay for play kind of deal. Okay. You have to. I hate to give a blanket statement because look, there are some judges where they said the judge goes, "Hey, I'm friends with this person," and the parties talk about it, and they say we still feel that you can be fair, because there are some judges who are able to be fair. Right. There are some judges that aren't, and those are the ones that you need to target with that sort of stuff. Because if your decisions are clearly biased, then that is a violation of people's rights and constitutional rights and all sorts of things.
How about a child that has meth in the system, and doggone well it's this party that gave that the meth was in the system, that the meth transpired in the system, but yet you still allow that person to have visitation. Would that be?
Well, we try not to cut off visitation, but what kind of visitation are we talking about? We're talking about overnight visits, unsupervised
like a week
visits?
At a time.
I mean, I think that's a child endangerment issue.
Okay. So as a DA, and this gets into my other question, as a DA, how could you work with the Child Protective Association? And there's a lot of CPA caseworkers that actually fib in court to get the kid taken away from mom or dad because maybe they don't like their personality.
Right.
Maybe they have their own bias about them, but yet they go and fib in court. How do you stop stuff like that?
We have a perjury statute. It very rarely gets used, but that is a charge the DA's office can file, and they should file, especially since a lot of those cases, I mean, you have CPS workers testifying on behalf of the DA's office. I mean, that's a serious issue. And whether that needs to be referred out because then there's a conflict or whatever the issue is, those do need to be referred out. Because if you have a CPS worker who's lying in court, where's the protection for the child? How many cases is that child going to the wrong parent? That's a scary, scary thing. And don't get me wrong, I sat on panels, I did forensic interviews when I did child abuse cases out in Nye County. I used to watch the forensic interviews. I worked with CPS. There are some great CPS workers. Those people need to stay. Everybody else needs to go. And if you're going to take it so far as you're going to walk into court and perjure yourself, then you need to be prosecuted for it.
Okay. Let me just move to a different topic real quick. Veterans Court. How do you perceive Veterans Court?
I think it's an absolutely necessary thing. I think veterans go through some things that regular civilians will never understand. I think that it drives a lot of substance abuse issues and mental health issues that don't get addressed. And we are not doing a service to our veterans who protect our freedoms if we are not taking those things into account. But I'll say the same thing about everything else. You work with people up until the point that you can't anymore, but they certainly should be given a shot at those programs and given a chance to address the issues. If you can't address the issues, there are ways to handle that. But certainly the veterans community, it needs to be addressed in the right way. Those people go through things that the rest of us couldn't possibly.
Right now, the current DA's office is telling veterans that they need to plead guilty to a case before they could enter veterans court. Isn't that by itself a violation?
I think that puts an undue burden when you look at somebody.
Especially when the veteran is convinced that it didn't happen.
Right. Right.
But don't want to go through that long, lengthy court trial, rather go through the Veterans Court program. Maybe they might see, hey, I might need some type of help in X, Y, and Z. But no, I didn't do that. But yet I got to plead guilty to it just to get the necessary help that I need. Why does the DA's office allow to get away with that?
That's a good question, because there is the 3363 program, which suspends proceedings, and while there is a guilty plea entered, no conviction is sustained against the person, and it's ultimately dismissed without a conviction ever being entered. I don't know why we couldn't do that in Veterans Court. I think they probably deserve that chance a lot more than some of the people who get the 3363 program. I say that being someone who went through the 3363 program. Mm-hmm. It's a sensitive community. Not to say the veterans are overly sensitive people. I'm not trying to make anyone out to be a snowflake. That's not where I'm going with this. But the sort of trauma and things that veterans go through is so different than any civilian could normally understand. And I think that needs to be taken into account.
Okay. Jim, you have anything else?
No, well, just interesting about that when you said the sensitivity issue. It actually is a sensitivity issue because, like, I watch a bunch of interviews and stuff of individuals that have come back from Afghanistan and different places, and they're driving and they're like freaked out because they're like looking around and they're like, wait a minute, that looks a little odd. Why is that just sitting on the side of the road? Because the IUDs and all that stuff going on. So it is a sensitivity issue, I believe. Just one last thing, really, and just you can just address it briefly. It's not really a question, more your opinion. I want to make sure I phrase this as nice as I can, because I don't dislike this person personally. But one of the comments and I overheard it when he was having a conversation with someone else, so it wasn't directed towards me, that, and he's the current DA, that, well, yes, there are things that go on in family court that maybe could be addressed by his office. There's so much going on in this community that, like, it would just take, it would take too much effort. We got bigger fish to fry. And so for me, the reason why that upsets me is because, like, when we were talking a little bit earlier, when I was saying about children and how much impact the family court has on children, and then with education being what it is, like, it is going to take effort and it is going to take resources, but for somebody to basically say they got bigger fish to fry is kind of concerning to me.
And I agree with you. And people need to keep in mind, the Clark County DA's office employs roughly 700 people, 170 attorneys. I mean, I know there's turnover, so that number fluctuates.
It's a large office.
And has a $53 million budget for the next year. How much more people do you need to address issues in the community? If you look at the schools, all the school violence, kids aren't getting the education they need. That leads to, poverty issues. That increases the crime in the community. When you have family court failing parents and maybe putting the kid with the wrong parent, so they don't have a good upbringing, and education and morals and stuff aren't focused on, that adds to crime into the community. I think the DA's office has a duty to look into these things, and you certainly have a big enough staff and budget to do it. You probably have too large of a staff and budget. It could probably be done more efficiently and save the taxpayers some money while also benefiting the community. So I think that's a cop-out. I think it's easy to say, oh, well, we have a high murder rate, or we need to protect the Strip, and we need to protect the tourists. What about the community members? Those are your constituents. The tourist trade is fantastic. Don't get me wrong. Vegas runs on its tourism industry, but there won't be anyone here locally if these things ultimately aren't addressed, if crime continues to get worse, if we continue to decriminalize things. So it's a total cop-out. I agree with you. And it's not something we should shy away from. Don't be afraid of family court. You're the DA's office. Prosecute cases that need to be prosecuted. Deal with corruption where it needs to be dealt with. And the community will be better for it.
What's the statute of limitation of domestic violence with strangulation?
Strangulation, I think they just kicked that up to, it was 3. I think it's up to 5 now, 5 years.
And why doesn't the DA's office effectively go after alleged criminals that have these that litigants put these, that moms or dads put these complaints about domestic violence with the DA's office, but they don't pursue the case because it's not within in their perspective within sufficient time. 2 weeks, 2 days, 3 days. Why don't they pursue those cases that the parent is strong enough to now file a complaint?
It's a painful policy they have, and it's not just DV, it's also a sex crimes issue as well. Not everybody comes out and discloses things immediately. One of my favorite sayings I've heard when I used to do sex crimes is, and it applies to domestic violence too, these crimes don't occur on the 50-yard line at the Super Bowl. They occur in a house, in a family unit where you've got kids involved and other loved ones involved, and there may be threats of violence if they come forward and other things like that. That's another sector that you need to have a real sensitive touch and victim witness advocates that know how to deal with these issues. Because I applaud any domestic violence victim that comes forward with a righteous charge. That unfortunately that we've, especially recently, it's been more publicized that some of these charges that come forward are not righteous and they're just used to get back at people. But it needs to be investigated either way. You need to come to a conclusion as to what happened, and you need to file charges where it's appropriate. And just saying that somebody didn't disclose for 2 weeks or a month or even a year, maybe that's how long it took them to get out of a toxic relationship. And they're away from this person. And now, granted, is your case going to be weaker? Probably, because you didn't get as much evidence as you could have earlier. But if there's text messages or photographs, and usually there are, because everyone's got a smartphone now, I don't know why those cases aren't being investigated. It's too easy to sweep it under the rug. And again, you have 700 people in your office, you have 170 attorneys, you have private investigators. Don't act like you don't have the resources to deal with these cases when you do.
I remember prior to D.A. Wilson was David Rogers, and he was trying cases. He did the OJ one. I believe he did the Murphy case with the Binion. Those high-profile ones he did. D.A. Wilson's been there 10 years now, I believe, because he did 2 years of Rogers and went for the election process. I have never seen him try the case. Have you?
As far as I'm aware, he has not, since he's been in that office.
What do you think that is?
I don't know. I think it's strange that myself, who I have far less years of experience than he has, have tried numerous cases in the time that he's been in office. I was barred in 2012. It's indescribable. So number one, you're the lead prosecutor of the county. You should be keeping your skills somewhat sharp in the courtroom. I think that's important, because how are you training people if you're not? But you almost have a duty to be in court, keeping your skills sharp, prosecuting high-profile cases, or even maybe not high-profile cases. Let some of your deputies take those. But you need to have a presence there in order to effectively lead the office, and I think that's severely lacking now.
Okay. What would you do different?
I certainly would pick up a file and walk into court, and probably more than one. But it's really a leadership and efficiency thing. I've actually been approached by some of Ozzy's former followers before he was out of the primary and said, look, we appreciate his view of leadership in the office. And I think he's right about that. There's a distinct lack of leadership. And I think both sides of the aisle agree on that issue. And that's one of the first things that has to change, because leadership, it's all top down. If at the top you're not leading and you're focused on your programs or sitting in your office or drinking coffee or whatever you're doing, when you're not in court, you're the people under you see that. And that's where the problems start.
Do you think this DA has a sense of entitlement?
I think that anybody who does anything for too long has a sense of entitlement. I think that comes with being comfortable in the position you're in. I would actually be for term limits for DAs, honestly. I think that almost every position should have a term limit.
How many years would you give DA?
I'd probably do 8 or 12, 2 or 3 terms, because at that point, number one, it's a stressful position. I think at that point, you're going to be stressed beyond belief, especially in a county as large as this one, especially if you're effectively doing your job. Yeah. And I think that's enough time where you've done your service to the community and you can go on and do other things. It's a high enough profile position where if you have ambition, you can move on from there.
Is there anything that we did not cover you would like to cover?
I don't think so. You've been very thorough as usual. It's always a pleasure coming on here. You've always been fair. And like I said, this was my first interview out of the gate was with you and Stephanie. So I always appreciate you guys having me on.
Jim, you have anything else for Mr. Treffinger?
No, I just appreciate you coming on, and I appreciate you answering these questions because, like I said, these questions tend to get ducked a lot, and we have to do. Let's just put it this way: not so much that not completely ducked, but like it gets frustrating for Steve and I because it's like, no, okay, well, how about and after the 8th follow up, it's like, all right.
Well, I promise never to do that to you guys.
And it's just frustrating because public service is supposed to be for the public, and I really appreciate your honesty and being willing to take on being a DA.
Thank you, appreciate it.
Well, Mr. Treffinger, Mark is going to zoom in on you, and this will be an opportunity to reach out to the people of Nevada. Since this is a general election, that means all parties could vote for you. So it's an open election that everybody could vote for you, whether you're politically affiliated or not. And you want to drive them to come to the voting booth and vote for you and put you as the conservative voice in the Clark County District Attorney's Office. And this is your shot to get them to come to you and your point of contact.
Thanks. Again, I'm Tim Treffinger, Republican nominee for Clark County District Attorney. I am the conservative voice in this race. I want you guys to know the fight's not over. I keep hearing, it's a primary race and I'm the underdog and all that, but I'm going to keep fighting all the way to Election Day. I'd appreciate your support. We need to bring conservative values back to the office. We need to bring leadership and efficiency and consistency back to the office. And I'm willing to do that. I'm willing to make the changes that need to be made. I'm not going to duck the hard questions as you've seen here today. And I think if you appreciate conservative values and you're concerned about the leadership in that office, you certainly should come out and vote for me in November. My point of contact is www.treffinger4nevada.com. You can reach me there with any questions or comments. I always respond to those relatively quickly. I'd appreciate any donations or support. If you want to knock doors or make phone calls, reach out. And again, thank you for your support. I look forward to the race in November.
Spell Treffinger for them, please.
It's T as in Tom, R-E-F-F as in Frank, I-N-G-E-R.
Thank you so much, Mr. Treffinger, for coming out. We really appreciate you. Jim, thank you. Folks, this is Steve Sanson, Jim Jonas with Veterans in Politics. Until next time.